welcome to the deep dive. You know, the world throws so much information at us, it's overwhelming. We're here to be your shortcut, really, cutting through that noise. We dig into the sources, pull out the key insights, maybe even some surprising facts you won't find elsewhere. Today, we've got three really big shifts happening. First, a huge Supreme Court ruling that, well, it really redraws the lines on judicial power in the U.S. Then we'll jump over to Europe, tech giants versus regulators on AI. A real high-stakes battle there about innovation, about control. And finally, NATO. A landmark summit, new alliances, new security challenges. These stories, they might seem separate, but they're actually deeply connected. Threads of power, policy.
Absolutely. And our job here is to go deeper than just the headlines. We've got the court opinions, think tank reports, all of it. We're going to synthesize that, give you the context, the core insights, help you connect those dots. Think of it as your fast track to being genuinely informed.
Okay, let's dive into this first big one then. The Supreme Court. June 27th, 2025. The decision drops in Trump v. CASA, Inc. And the core issue. It's about something called universal injunctions.
Right.
These are court orders that don't just stop a policy for the people suing, but like nationwide, for everyone.
Yeah, a single judge potentially halting a policy across the entire country.
Exactly.
Yeah.
And it's this huge debate, right?
Yeah.
About how much power courts should have to check the president or government agencies. This ruling is massive.
It really is. And this question, about whether these injunctions are proper, it's not new. The Solicitor General, that's the government's lawyer, basically has been raising this issue for years across different administrations because the use of these injunctions has just exploded recently. So the court finally had to weigh in. Can judges do this?
And the majority, what did they find?
Well, the headline is, the government was likely to succeed on the merits. Why? Because, they argued, district courts simply lacked authority to issue universal injunctions.
Lacked authority. That sounds fundamental, not just a procedural thing.
Oh, it's fundamental. They're essentially saying judges went too far. Their reasoning, it gets really interesting here, they went all the way back to the Judiciary Act of 1789.
1789?
Yeah. That act lets federal courts issue equitable remedies, fair solutions, injunctions, that kind of thing. But the court said, look, those powers were limited to what courts traditionally did back then at the founding, and universal injunctions. They lack a founding-era forebear. That's the key phrase.
So basically, we didn't do this back in Washington's day, so we can't do it now.
That's the gist of it. They said historically, courts consistently rebuffed requests for relief that extended beyond the parties, actually, in the lawsuit.
Okay, so if it's not traditional, how do they address things like, modern class actions where one case can affect a whole group?
Good question. They talked about an old tool called bills of peace.
Bills of peace, never heard of it.
Yeah, it's archaic. Think of it like an early version of a class action, but for like a small and cohesive group facing the exact same issue. The court's ruling could bind everyone in that small group, even if they weren't personally in court.
Okay, so small group, specific issue. How is that different from a universal injunction?
Totally different scale. The majority argued universal injunctions let courts basically create de facto class actions at will, but without all the procedural safeguards built into Rule 23, the modern rule for class actions.
So it bypasses the proper channels, in their view.
Exactly. And the government added a bunch of practical arguments, too. They said these injunctions, they lack a limiting principle. They encourage forum shopping plaintiffs, hunting for a sympathetic judge anywhere in the country.
Right. Find one judge, get a nationwide freeze.
Yeah, and it's asymmetrical. A plaintiff needs one win. The government has to win everywhere.
That does sound tough.
Leads to rushed, high-stakes, maybe low-information decisions, and it's an improper intrusion on the executive branch's job.
Okay, I can see the government's points there. But didn't Justice Kavanaugh raise a counterpoint?
Yeah.
Something about patchwork policies being a mess.
Yes, exactly. In his concurring opinion, Kavanaugh pointed out that while the majority focused on history, the alternative where a federal policy applies in some states but not others, that kind of patchwork scheme, is often not especially workable or sustainable or desirable.
Right. Imagine trying to enforce something like, immigration rules or environmental regs differently, state by state based on court rulings. Chaos.
Precisely. It creates its own set of problems, even if it avoids the universal injunction issue.
Which brings us to the dissent. Justice Sotomayor, joined by Kagan and Jackson, they had a very different take, didn't they?
Oh, absolutely. A powerful dissent. They started right at the source, the executive order that sparked the whole case, the one trying to change birthright citizenship. The dissenters flat out said it likely violates the Constitution.
Okay, bold start. What was their reasoning on the citizenship part?
They went straight to the 14th Amendment, the Citizenship Clause. All persons born or naturalized in the United States, you know the one,
Mm-hmm.
subject to its jurisdiction.
Right. They stressed its history rooted in English common law, just solely, citizenship by birth on the soil, designed specifically to overturn the horrible Dred Scott decision. And they pointed to United States v. Wong Kim Ark from 1898, which cemented birthright citizenship, barring very narrow exceptions.
The long-standing precedent.
Decades of it. Congress reaffirmed it, the executive branch itself, through the Office of Legal Counsel back in '95, called denying it unquestionably unconstitutional. So the order was a radical break.
Okay, so they established the underlying order is likely unconstitutional. Then how did they defend universal injunctions themselves?
They pushed back hard on the historical argument. They said, look, universal injunctions aren't new. They cited cases like Pierce v. Society of Sisters in 1925, West Virginia Board of Education v. Barnett in 1943, cases where the Supreme Court itself affirmed or issued orders that clearly helped people beyond just the named plaintiffs. So they're saying we've done this before.
Exactly. And they argued it's sometimes necessary for complete justice, especially when a government action is patently unconstitutional and harms large scattered groups. Think about it. How could you possibly bring every single person affected by a nationwide policy change into one courtroom? It's almost impossible.
That makes sense. So what happens if courts can't issue these broad orders? What's the chaos they predicted?
They paint a pretty stark picture. A narrower injunction creates this unworkable two-tiered scheme. Imagine, like, your citizenship status or your kid's eligibility for Medicaid or SNP, depending not on the Constitution, but on whether you happen to live in a district where someone successfully sued.
Yeah, that sounds completely unmanageable.
Huge burdens on parents, on hospitals trying to figure out who's a citizen, on government workers at every level, states losing millions in federal funds. And the dissent really emphasized the harm to newborns, losing a most precious right, potentially becoming stateless, denied essential services, even facing deportation, gravest harms imaginable.
Wow.
And Justice Jackson, in her separate dissent, hit the rule of law point hard. Letting the government violate the law for anyone who hasn't sued yet, that carves out a huge exception to the rule of law. It makes a mockery of the court's duty.
A really fundamental disagreement on the role of the judiciary there. Okay, let's shift gears. From court battles over government power to a different kind of power struggle. We're heading to Europe. The digital realm, the EU AI Act.
Right. This is a big one. Billed as the world's first comprehensive AI law, the goal is global standards for safe and ethical AI using this tiered risk-based framework. Key parts are supposed to kick in this August 2025.
But not everyone's rolling out the welcome mat. We're seeing major tech players, Meta, Apple, through their lobbying group, CCIA Europe, which also has Google's parent Alphabet. They're pushing back. They're trying to delay implementation. So what's the friction here?
Well, the industry's main worry, or what they're saying anyway, is that a rushed deployment could stifle innovation, especially for these big, complex, general-purpose AI models.
The engine's driving a lot of the current AI boom.
Exactly, and there's some evidence businesses aren't ready. A recent survey found over 2/3 of European companies are still scratching their heads trying to figure out the technical requirements.
Okay, so practical implementation challenges.
Yeah, and they argue that without clear guidance, the act puts an unfair burden on businesses, especially smaller firms.
The ones without huge legal departments.
Right. They can't easily absorb the compliance costs, and this uncertainty, it means companies might divert money and people away from actually building new AI products and towards just figuring out the rules.
So it's this classic tension.
Yeah.
Innovation versus regulation. But is there something specific about AI that makes this harder? The speed of change, maybe?
That's definitely part of it. AI is moving incredibly fast, and the global picture is messy, right? You've got the EU aiming for this comprehensive, rights-focused approach. The US, it's more executive directives and piecemeal state regulations all over place.
And China.
China's focused on state-led control and surveillance. Very different priorities.
So companies operating globally are caught in the middle, trying to follow different rule books.
It's a real strategic dilemma. How do you build AI that works everywhere when the rules are so different? This lobbying push against the EU Act, it really shows this gap, this disconnect between policymakers' ambitions and real-world implementation challenges.
So what does this mean for the EU? They want to be the global rule setter here.
Well, the next few months are crucial. Will the AI Act become the gold standard, a model for responsible innovation? Or will it be seen as, regulatory overreach, a warning sign? It's really hanging in the balance.
Okay, from AI rules to global security rules. Let's turn to NATO. Big summit in Washington, July 10th, 2024, the 75th anniversary. And a major development, Sweden officially joined as the 32nd member.
Yeah, that's a significant boost for security in the Baltic Sea and the High North. Really changes the strategic map up there.
And the summit declaration, what were the key takeaways?
Well, it reaffirmed the core missions. Peace. Transatlantic security, that ironclad Article 5 guarantee, is still central in democratic values. Good news on spending. Two-thirds of members are hitting or exceeding that 2% of GDP target. But the world's getting rougher, so now they're talking about needing more than 2% annually. The baseline is shifting upwards.
Right, and the biggest shadow over the summit, inevitably, was Russia's war in Ukraine.
Absolutely. That was front and center. NATO strongly condemned the invasion, called it a significant disruption, and labeled Russia the primary threat to security.
Holding Moscow solely responsible for war crimes, refusing to recognize annexed territory.
Right. Demanding withdrawal from Moldova and Georgia, too. Standard stuff, but strongly worded.
But then there was the China language. That seemed new.
Very new and very significant. The declaration specifically called China a decisive enabler of Russia's invasion.
Decisive enabler, wow.
Yeah. Pointing to the No Limits Partnership, supplying dual-use materials that help Russia's war machine. This wasn't just calling China a challenge anymore. This was the first overt mention of China as a direct party involved in the Ukraine war by NATO as a whole. Big implications for Beijing's reputation.
And what about direct support for Ukraine? Any concrete steps?
Yes, several. They launched NSC-2, NATO Security Assistance and Training for Ukraine, basically streamlining support. Also JTEC, a Joint Analysis and Training Center, a big financial pledge, $40 billion long-term, and a senior representative based in Ukraine.
So doubling down on support and membership.
Ukraine's on an irreversible path to join NATO. That was the language. But it's conditional on reforms and, obviously, the war situation.
Okay. Strong commitments. But then there's the analysis from places like the Clinton-Dale Institute pointing to the U.S. election in November. The elephant in the room.
Yeah, that looms large. There are real worries about what happens if former President Trump wins again.
What are the main concerns?
A potential major blow for the cohesion of the alliance. The fear is decreased U.S. involvement in European defense under an America-first approach.
And his comments about ending the war quickly.
Concerns that his promise to resolve the war in 24 hours really means pressuring Kiev to give up territory. Moscow's reportedly waiting for the election results before even considering peace talks.
So a lot riding on the U.S. election outcome, even if Trump doesn't win.
Even then, a Republican-controlled Congress could still potentially block or slow down military aid to Ukraine. So U.S. political division is a risk factor regardless.
Which puts the focus back on Europe. If U.S. support wavers, are European allies ready to pick up the slack?
That's the billion-dollar question, or maybe trillion-dollar question. They'll need to significantly step up their efforts. Ukraine itself still faces huge challenges, like a serious lack of sufficient personnel. Right. Militarily retaking all lost territory. That looks impossible right now without massive sustained aid.
So aid needs to keep flowing, plus diplomacy.
Exactly. Consistent aid, consistent diplomacy for a just peace. But for Europe's own defense readiness, experts say NATO forces are ready to fight tonight.
Okay.
But not well prepared to deter and fight a protracted war. There are still critical European shortfalls. Any big fight in Europe would heavily rely on U.S. forces.
So what needs to happen?
Boost industrial capacity, make more shells, more weapons, fill capability gaps, strengthen national resilience. But the formal NATO planning process, the NDPP, it's slow. Results aren't due till October 2025.
And the personnel issue, especially for countries without conscription.
That's a real bottleneck for places like Germany, the Netherlands. All volunteer forces struggle to get enough people. The idea of reintroducing mandatory conscript service is back on the table. It's controversial, but might be needed for enough reservists for a long conflict.
Wow, conscription. That's a major shift in thinking for many European countries. Finally, how did the world react to this NATO declaration, especially the tough talk on Russia and China?
Pretty mixed bag, as you'd expect. China denied everything, said its ties with Russia were just economic, accused NATO of trying to justify expansion into Asia.
Okay. Anyone else?
Hungary was worried about the harsh language towards China. They want NATO to stay purely defensive, not an anti-China bloc.
But others were supportive.
Oh, yeah. Poland, South Korea, Japan, they praise the strong stance, the focus on security cooperation. They see the threat clearly.
Interesting. And any notable omissions?
Al Jazeera pointed out the conspicuous lack of any mention of Gaza or Palestine in the declaration or during the summit talks, a potential blind spot depending on your perspective.
So wrapping this all up, we started with the U.S. Supreme Court redrawing the lines of judicial power with that universal injunction ruling. Then we saw the EU grappling with tech giants over AI regulation, setting boundaries for the future. And finally, NATO redefining its security boundaries, reclassifying threats like Russia and China.
Yeah, the common thread really is this redefining of boundaries, legal, technological, geopolitical. It's happening everywhere.
And these shifts, they aren't happening in isolation, are they? They all interconnect.
Absolutely not. Think about it. How a court interprets its power affects how regulations are enforced, which influences international relations and security concerns. It's all linked. Understanding these details, these nuances in court rulings or summit declarations, it's really crucial if you want to grasp the bigger picture. These decisions impact all of us.
So a final thought for you, our listeners. With all this rapid change in law, tech, global power, what do you think is the single biggest challenge facing leaders right now? And maybe more fundamentally, how will the very idea of the rule of law hold up in this increasingly complex, shifting world? Something to chew on. We hope this deep dive gave you some clarity, maybe spark some new questions. Keep exploring, stay curious. We'll catch you next time.